Get ready for the dictation. Start. The law on the issue of dying declaration can be summarized to the effect that in case the court comes to the conclusion that the dying declaration is true and reliable, has been recorded by a person at a time when the deceased was fit physically and mentally to make the declaration, and it has not been made under any tutoring, duress, prompting, semicolon, it can be the sole basis for recording conviction. Stop. In such an eventuality, no corroboration is required. Stop. It is also held by Honorable Apex Court in the aforesaid case, that a dying declaration recorded by a competent magistrate would stand on a much higher footing than the declaration recorded by office of lower rank, for the reason that the competent magistrate has no axe to grind against the person named in the dying declaration of the victim. Stop para. Deceased survived for 11 days after the incident took place. Stop. Her dying declaration was recorded by Preeti Jain, Nayab Tehsildar, and Dr. Mahendra Pal Singh, appended certificate of mental health of the victim before and after making of dying declaration, which is proved as Exhibit K 8. Stop. Both the above witnesses, PW10 and PW11, are absolutely independent witnesses. Stop. In the wake of aforesaid judgments of Lakhan (Supra), dying declaration cannot be disbelieved, if it inspires confidence. Stop. On reliability of dying declaration and acting on it without corroboration, Honorable Apex Court held in Krishan versus State of Haryana (open) 2013 3 Supreme Court cases 280 close, that it is not an absolute principle of law that a dying declaration cannot form the sole basis of conviction of an accused. Stop. Where the dying declaration is true and correct, the attendant circumstances show it to be reliable and it has been recorded in accordance with law, the deceased made the dying declaration of her own accord and upon due certification by the doctor with regard to the state of mind and body, then it may not be necessary for the court to look for corroboration. Stop. In such cases, the dying declaration alone can form the basis for the conviction of the accused. Stop. Hence, in order to pass the test reliability, a dying declaration has to be subjected to a very close scrutiny, keeping in view the fact that the statement has been made in the absence of the accused, who had no opportunity of testing the veracity of the statement by cross-examination. Stop. But once, the court has come to the conclusion that the dying declaration was the truthful version as to the circumstance of the death and the assailants of the victim, there is no question of further corroboration. Stop para. In Ramila Bain Hasmukh Bhai Christie versus State of Gujarat, 2002 7 SCC 56, the Honorable Apex Court held that under the law, dying declaration can form the sole basis of conviction, if it is free from any kind of doubt and it has been recorded in the manner as provided under the law. Stop. It may not be necessary to look for corroboration of the dying declaration. Stop. As envisaged, a dying declaration is generally to be recorded by an executive magistrate with the certificate of a medical doctor about the mental fitness of the declarant to make the statement stop. It may be in the form of question and answer, and the answers be written in the words of the person making the declaration stop. But the court cannot be too technical, and in substance, if it feels convicted about the trustworthiness of the statement, which may inspire confidence, such a dying declaration can be acted upon without any corroboration. Stop para. From the above case laws, it clearly emerges that it is not an absolute principle of law that a dying declaration cannot form the sole basis of conviction of an accused when such dying declaration is true, reliable, and has been recorded in accordance with established practice and principles, and if it is recorded so, then there cannot be any challenge regarding its correctness and authenticity. Stop para. In dying declaration of deceased exhibit ka 8, it is also important to note that it was recorded on 25/2015 and the deceased died on 24/5/2015, while the incident took place on 13/5/2015. Stop. It means that she remained alive for 4 days after making dying declaration. Stop. Therefore, truthfulness of dying declaration can further be evaluated from the fact that she survived for 4 days after making it, from which it can reasonably be inferred that she was in a fit condition to make the statement at the relevant time. Stop. Moreover, in the dying declaration, the deceased did not unnecessarily involve the other family members of the accused appellant. Stop. She only attributed the role of burning to her husband. Stop.